But going back to you, that all the more proves the point in response to your question. You're looking at engagement and whether it continues, but I think what the judge is inevitably saying is you need to know the purpose, because you may just say, I can't do this. I'm not gonna go from 15 million to 7 million in a year and a half. Now, again, in New Jersey, as maybe in other parts of the country, most real estate's down by 30% over the last 24 months. So some of it does become doable. But it's a dilemma for you, and obviously goes to your ethical and professional capabilities.
It also goes to the issue of what your strategy is at the outset and how you're filling out your bankruptcy petition and your schedules, because you're signing, or debtor is signing under the penalty of perjury that the debtor believes the value of its property is X dollars on the petition
That's
date.
why my clients all write unknown.
Which
I've said some judges, but I say it really is unknown.
Honestly, without an appraisal, I will not counsel a client, particularly a client with a large piece of real estate or a valuable piece of real estate, to put a value on a petition. It's an admission. It's and will certainly be used by the secured creditor under the judge's example at the confirmation hearing. You're going to say, hey, judge, this debtor on its schedule when it suited it, okay, when it filed the bankruptcy case, said the property was worth 15 million bucks, okay? Stood behind that at the stay relief hearing and said 15 million bucks. Now is flip-flopping and is cutting the value in half because it suits the debtor's needs at confirmation.
Sketchy, I think is the word.
Sketchy.
Sketch, right?
It's sketchy back, as they
Sketch
say.
moment.
Now, even though Richard's clients say on their petition unknown value, that's never going to satisfy a Chapter 7 trustee. Chapter 7 trustee is going to ask at that creditors meeting, which is one of the events right after you file, meeting of creditors, it's an opportunity to examine the debtor. The Chapter 7 trustee is going to demand proof of value. Now, it doesn't mean a debtor has to go out and pay for an appraisal. The debtor will come in. We've seen when I was a trustee, you see everything. You see Zillow. You see, I know, a horrible word. You see a tax assessment, which is meaningless. You see an appraisal that's 10 years old. There has to be something. And then the burden rests on the trustee, if you believe it. The trustee may go to Zillow. The trustee hopefully has a relationship with an appraiser that they can go to and check. Yeah.
This goes to a question, I think. Oh, no. This goes to a question that we had emailed in. I think that you've kind of seen. And if I can, is this time to interject that question?
Sure.
This came in, and I'm going to read the scenario. Borrower has filed for bankruptcy. As part of the process, appraiser's been hired to complete an appraisal assignment. Appraiser turns in their report to the attorney representing the borrower. The attorney calls back and tells the appraiser that his report looks a lot different from the appraisal report used in the lending process that he requested from the lender. Appraiser looks at the report, tells the attorney that it wasn't an appraisal but an AVM. The attorney says, how can this be? His clients made a loan application and was told by the loan officer that an appraisal would have to be completed as part of the loan criteria. Borrower received a call, was told that the appraisal was completed and they had no problems with value. The loan officer stated that based on the value of the home, the borrower would actually qualify for a larger loan. The borrower states that if the lender had ordered a properly completed appraisal, the value would not have been overinflated and the loan balance would have been lower. In calling an AVM an appraisal, is this a misrepresentation? That's the first question. If so, does it reduce or affect the lending institution's security? If a loan officer reports to a value to a borrower based on an appraisal ordered by the institution, how can a borrower rely on that statement? And what are the possible reactions, and I understand different courts, different outcome, courts might have.
All right. Do you want to go first?
Okay, so the bottom, if we can boil that down, it sounds like it's is whether or not that fact that the bank used an AVM, whether or not that means anything or helps the borrower. Right?
Well, could that give rise to lender liability on the bank's part? And remember, appraisers or agents of the bank in certain situations, is there any liability there? It's an interesting question. Now, I'll give my Miranda warning. Nobody can rely on anything I say. I'm not bound by it. I don't mean it. I'll change my mind tomorrow. But when I saw that hypo, I looked to see if any cases that touched on it. And I found this case, and I'm going to read the language. It's from a federal district court in Kentucky a year ago. And it was in a situation where there was an inflated appraisal, and the inflated appraisal permitted a borrower to borrow more than they could repay, and the borrower brought suit, claim under many of the predatory, consumer predatory loan statutes that are out there in both the federal and state scheme. And the court noticed that this was a refinance transaction, and it says, and it's a little long, but I'll read it. In a refinance transaction, the appraisal is performed primarily for the benefit of the lender. The appraised value of the property helps the lender to determine the maximum amount of credit it can safely lend and ensures that any loan transaction entered into is adequately collateralized. In this context, a falsely inflated appraisal, now this wasn't a choice of what type of appraisal, but it's analogous. A falsely inflated appraisal harms only the lender. If the loan based on the false appraisal is foreclosed, the lender is left with an asset that is worth less than the amount loaned to the borrower. No harm flows from the fraudulent appraisal to the borrower. Rather, if any fraud was present in the appraisal process, it was the lender that stood to be harmed. So if the lender is negligent, they're the one to be harmed, not the borrower in this situation. In contrast, when a home is appraised in advance of an initial purchase, the appraisal benefits not only the lender, but also the purchaser. This type of decision, which basically says the purpose of an appraisal in a refinance situation is for the benefit of the lender. It's not the benefit of the borrower. And it may be that the lender advises the borrower of the amount and says you could qualify for a larger amount. It may be negligent, it may be sloppy, it may be reckless, it may not be wise to choose a particular type of appraisal. Unless you can establish a fraud, which is an intentional misrepresentation, knowingly done in order to deceive, you're not, I don't think, going to prevail. There are a lot of cases here in New Jersey. It doesn't deal with appraisals. It deals with the income and expense statements filled out by borrowers, that they're helped along by mortgage brokers, and whether or not. And most of the cases that have come in which the borrower ultimately brings a lawsuit against the lender saying, you told me I would qualify for this loan based on the numbers. The lender is not going to be liable unless they actively participated in the fraud by changing numbers. Just because they don't verify the numbers, just because they accept the debtor's numbers, isn't a fraud. And I think that's going to be the direction of it. Again, what is the purpose of the income and expenses? It's to protect the lender in making the decision to loan. The appraisal, what's the purpose? I think, and I agree with this court in Kentucky, it's to protect the lender to ensure that there's proper collateralization. It's not to say to the borrower, go ahead, sky's the limit, or here's the limit. But we face, and I face a lot of this litigation with borrowers now looking to find whatever fault they can to get out from under the loan. I mean, I had a case, and we go into war stories, it's dangerous. I had a case in which a young woman, the foreclosure had gone on 6 years. The note went into default day one, maybe a month later. She fought in the state court for years and years, finally filed multiple bankruptcies, and comes to me in a stay motion where the lender says, I want to deny the debtor's plan, I want permission to finally have this sheriff's sale. And she says to me, Judge, I don't know who to pay. This loan has been sold, I was never given notice, I don't know, that's why it's in default, I never know who to pay. And I looked at her and I said, well, why don't you start with the person suing you? That would be logical, wouldn't it? I am not familiar. The argument with all these false affidavits and the foreclosures is that you don't want a debtor or borrower to have to worry that she pays one person, another person's going to sue them. Never happened. If it happened once in this entire country in the last 30 years, that'd be more than I expect. Usually you don't get sued. And if you do, it doesn't take much to prove you paid one party. I asked the young woman, do you have the money? If you weren't paying for the past 6 years, then I'll help you. We'll confirm a plan. You're going to pay the arrears over the next 5 years. Let's use the money that you have to fund the plan. I don't have any money. Okay. I mean, there are abuses. You all know of abuses in the mortgage loan industry. You know of abuses with appraisals. They've been documented. There are abuses when the people have been taken advantage of. It's fact sensitive. So a long way around answering the question, unless I see that there was reliance by the borrower and that there was some wrongdoing, that's more than negligence. Negligence, let a stockholder of the bank sue the employee or get him fired for giving the loan. That's where the harm came. Let's see if there's wrongdoing. If you massage numbers or you direct the appraiser, we'd like to see a higher number. It's a little different. But just choosing which type of appraisal, even if it doesn't make sense, it may not what you all want to be here as far as the use of these computerized listings, but I don't think that in and of itself is negligent. It creates a liability.
Judge, we got about 10 minutes. I don't know if we want to.
There are some legitimate